first state witness in Senzo Meyiwa's murder trial, Sergeant Thabo Johannes Mosia, has told the High Court in Pretoria that he responded to the crime scene on the night of the incident. The police officer spent the day giving a detailed description of what he found on the scene of the soccer star's murder 8 years ago. Meyiwa was gunned down at the Forest home of the mother of his then-girlfriend, Kelly Kumalo. Mosia says when he arrived, he already found the area cordoned off.
I then protected and secured some visible evidence found on the kitchen floor, which was a bullet jacket, a black white Scotch hat, and a walking stick. I processed the scene for photography and forensic investigation.
Mosia explained how a provincial task team was deployed to help with investigations the following day.
We investigated the scene together with the task team. And as we were investigating, then we followed the movement of the bullet, which was the bullet hole which was at the back of the door, kitchen door. We traced the movement of the bullet and managed to find the bullet on the kitchen top of the kitchen unit, behind the glass jars.
While still on that murder trial of the former Bafana Bafana captain Senzo Meyiwa, let's speak about the importance of the evidence that has been collected for this trial and how that could affect the state's case. We're joined now by University of Pretoria criminal law expert Dr. Llewelyn Curlewis. Dr. Llewelyn, good evening to you. Thank you for your time. Look, the state has made it clear that it's going to rely heavily on forensic evidence to prove especially the association between the bullet that was found on the scene of the crime and link it to the firearm of accused number 3 in this particular case. But from what you're hearing so far, let's just perhaps talk about that aspect, the way in which the state's case is going to rely on this evidence.
Right. Let's first start with the basic principle, and that is that all evidence must be relevant in order to be admissible in a criminal trial. That's the first point of departure for all types of evidence. In essence, the criminal law and procedure distinguish between 3 types of evidence. So-called oral evidence or viva voce evidence, that is the evidence of witnesses, obviously. In the second instance, documentary evidence. In this instance, that might be the post-mortem report, the sketch plan and the photographs that the sergeant referred to in his evidence today in the High Court. And then in the third instance, you get what is known as real evidence. That is nothing but objects, say, for example, the walking stick that was found on the scene. Mm-hmm. Now, you will agree with me that it is paramount that forensic evidence that links the accused to the scene of the incident and the murder scene is crucial in most instances. And if the state already indicated that they are going to rely heavily on forensic material and forensic evidence, then that is self-explanatory because they want that nexus, that link between the accused and the scene of the accident of the murder to be proved beyond a reasonable doubt in court.
When we look at it from that angle, given the fact that there is ballistic testing that can take place to determine, let's say, a link between a bullet that has been fired and a particular firearm, but that only solves the issue for one of the suspects, what happens to the rest? Yeah.
Remember, there are numerous principles that is applicable in this instance. Yes, of course, wherever one specific accused is directly linked with the murder, then it's self-explanatory that that specific accused had more to explain than, for example, the others. But it doesn't stop there. There's also a principle in our criminal law known as the common purpose principle. in the event that his co-accused can be linked to him and directly also contributed to the murder one way or another, then our law says that the judge might in this instance also find them guilty as either then co-accused, co-accomplices, whatever the case may be. But there is a principle known as common purpose in our law that will link those other individuals also if there is sufficient evidence, obviously, to do so. But you remember in this specific instance, the sergeant already indicated that the jacket of one of the bullets were found in the kitchen door, if I can remember correctly, indicative of the fact that according to his evidence, his expertise, and remember he's called as an expert witness to a large extent as well, because that is his expertise over 14 or 15 years in the police force, indicates that they got entrance to the premises by the front door, the kitchen door. So obviously one would expect that at some stage there will be more evidence to also take it from there and to indicate where the various individuals were situated at the night of the murder. But that is more or less how we go about in proving a case beyond reasonable doubt in criminal cases.
Sergeant Meyiwa was also asked a number of times to give an explanation for these swabs that he said were collected on scene, and to explain how these swabs are collected, what they are. What is the purpose of that?
Well, obviously, if there was any form of tampering anywhere in the chain of evidence, in other words, tampering from the moment that those samples were taken up to the moment and the final analysis were made by the various experts in that specific field of expertise, if there's any indication that there was tampering with that evidence, then obviously it cannot be used in the courtroom. So one of the typical questions in cross-examination that will be forthcoming is to establish whether there was any interruption in the link. In other words, in that causal, that nexus that I've referred to, we call it the chain of evidence between the taking of the sample and obviously the final analysis, the certificate that will then be issued in terms of Section 212 of our Criminal Procedure Act to be allowed and admissible in court. That's the reason for that issue.
It's often one of the things that is leveled as a critique for our forensics officials who are responding to crime scenes, that the collection of evidence, the tampering with evidence, unfortunately leads to it being inadmissible in a lot of cases, and therefore having the state unable to secure successful convictions.
Yes, you must remember that in terms of our Constitution, the accused must always get the benefit of the doubt, because a person is presumed innocent until proven guilty. So where there's doubt in the mind of the court that a specific piece of evidence should be admissible or not, then the court must always rule in favor of the accused, and in this instance in favor of the defense. A court will rather disallow evidence rather than to allow inadmissible evidence, because the prejudicial value of otherwise inadmissible evidence against an accused is so paramount that might make the difference between a conviction and an acquittal at the end of the day.
Llewelyn, I'm also mindful of the fact that, the defense is sitting down, listening to this evidence with clarity. What are some of the gaps that you think they might be wanting to hear of, or even may want to identify through the course of this particular evidence?
What will happen first and foremost is the state must decide what evidence they want to introduce. The moment they go beyond calling oral evidence, in other words, mere eyewitnesses, for example, maybe even his former girlfriend, Madam Khumalo, and they want to introduce, say, for example, forensic evidence, as they've indicated, the ballistic evidence, for example. That is the stage where the defense will then intervene and ask themselves whether they can find some gap, loophole, if you'd like, in other words, in that chain of evidence between the taking of the sample of the ballistic evidence and, say, for example, the end analysis. Because the moment they can prove that there was an interruption in that chain, then they will probably ask the court to disallow that specific piece of evidence. But you must remember, it's only one piece of the puzzle. A court can still, nonetheless, convict on the remainder of the evidence. But the weight attached to a specific piece of evidence will depend on the admissibility thereof at the end of the day.
Llewelyn, when you talk about an interruption in the chain of this evidence, what does that mean? Is it how it moves from point A to point B?
That is exactly what I mean. You'll see that during the course of the evidence by the state, they will have to prove, and in other words, score each and every person that actually touched or worked with a specific sample of the evidence from the moment it was taken at the scene until it was delivered to the final forensic expert to analyze it. Each and every individual that touched the evidence or was responsible to have it under his guard must come and testify one way or another that during the time it was in his or her presence, it was not tampered with or opened or contaminated in any way whatsoever. That is unless the defense obviously is willing to admit that there was no such interruption or a possible tampering, which in this instance I do not think they will do.
Criminal law expert with the University of Pretoria, Dr. Llewelyn Curlewis, let me thank you for your time tonight on News at Prime.